Hello everyone, welcome to Court with Krissy. For the record, all attorneys featured in these videos are actual attorneys. I myself am not an attorney, nor do I portray to be an attorney. I'm a businesswoman. And now a quick message from Ms. Moore from the second clip. Ms. Moore, while you're at CMU, take a business law class with Mr. Matthew Coffey. I checked ratemyprofessor.com and he's still active. I bet he's reached Silver Fox status by now. You'll thank me later. I hope you like it. Court with Krissy is now in session.
Your Honor,
Yes.
before we call the next case, I'd like to make, as long as we're on the record, I would like to make a record.
Okay.
I would like to be present in the courtroom for the arraignments. And I was informed that because there is no bailiff, I cannot be present in the courtroom. I would point out to the court that MCL 600.1420 states the sitting of every court within this state shall be public, except that a court may, for good cause shown, exclude from courtroom other witnesses in the case when they are not testifying, and may in actions involving scandal or immorality exclude all minors from the courtroom unless the minor is a party or a witness. This section shall not apply to cases involving national security. One, this morning, we have no minors involved. We have no national security. I am being excluded from the courtroom. Court Rule MCR 6.006 talks about the preferred mode and the presumed mode of hearings in district court. The preferred mode states the use of video conferencing technology shall be the preferred mode for conducting arraignments and probable cause conferences for in-custody defendants. I believe that statement indicates that only for in-custody defendants is the preferred mode Zoom. Paragraph 2 states the presumed mode in all other criminal proceedings, the in-person appearance of parties, witnesses, and other participants is presumed. Absent anybody who is in custody, I believe the presumed mode for arraignments is in person. And Court Rule MCR 8.116D1 states access to court proceedings, except as otherwise provided by statute or court rule, a court may not limit access by the public to a court proceeding. By keeping me out of the courtroom in the very cases which I have initiated through the filing of criminal complaints, I am being kept out of the courtroom. I will not appear for any more arraignments this morning via Zoom. My request to appear in person has been denied. I would just like to make a record of that.
Thank you, Mr. Rossiter. Well, I do appreciate that. This, and it is on the record now, this isn't actually the venue for a discussion like this.
I'm not looking for a discussion. I wanted to place my objections on the record.
Okay, thank you, sir.
Thank you.
All right, thank you. Sir, can you hear us?
Yes.
Good morning, Ms. Moore.
Good morning.
We are on the record in case number 24-2609SM. You're appearing for arraignment purposes this morning. You're appearing with Ms. Mistley, the defense attorney available through the Indigent Defense Counsel here to assist you. And Ms. Mistley, did you have opportunity to review the allegations on the complaint, nature of the offense, and the possible maximum penalty with Ms. Moore?
I did, and we will waive a formal reading of that misdemeanor complaint and her pleas of not guilty and request the assignment of counsel.
So in order to complete a petition for court-appointed attorney, yes?
I haven't talked to an actual lawyer. I don't want anybody to plead for me at this moment. I've never heard of an arraignment attorney. I understand this woman gave me a call. I've been through these court cases. I have never heard of an arraignment attorney. I'd like to talk to an actual attorney before somebody else pleads not guilty for me. I'm not trying to be disrespectful. I just want to
The Michigan Indigent Defense Counsel provides a defense attorney for
Yes.
every person who is arraigned. Ms.
And I-
Mistley is the attorney through the Michigan Indigent Defense Council who is assisting you in this arraignment.
So she's not everybody's arraignment attorney, she's just mine.
Now, she is the arraignment attorney for everybody that will be arraigned today, but she
Right.
is not your court-appointed attorney for your case.
And
So, go ahead.
I guess I'm trying to say like, I would like to talk to an actual lawyer attorney, not a arraignment attorney, a lawyer that is going to be defending only me.
Right. Well, you can't have that if you're going to request a court-appointed attorney. We have to go through a process, and then if you qualify, that attorney gets appointed. That attorney would be in touch with you by the 1st of next week.
Yes.
But that attorney would be your attorney for the case moving forward. The arraignment attorney is for everybody's protection, right? To make sure that you understand the charges, to make sure you understand your rights, to make sure that you understand the process, to make sure that you are aware of why you're in court. But it's just for those purposes. So the arraignment attorneys don't want to talk about all of the facts of the case and get involved with how it is that you will proceed going forward. They want to know some basic things about those that I just mentioned, your rights, the maximum penalties, what you're charged with, so that you understand this process. And so the arraignment attorney is a lawyer, and Ms. Mistley happens to be a very good attorney.
Well, and I'm not saying that she's, I don't mean to like come off disrespectful at all. I'm not saying that she's not a good lawyer. I just want to make sure like I'm not pleading something and we haven't even been able to go over like anything at all. Cause I just heard like she pleads not guilty. I never said that I was gonna plead not guilty.
Ma'am, that's exactly what we discussed when we had a telephone conversation.
That's what you discussed. That's what you told me to say. Is it not?
Okay.
I don't
But
want.
that is her role in this process, right? To counsel you for the arraignment only. So
I
after the arraignment, if you qualify for a court-appointed attorney, that attorney would be in touch with you by the 1st of next week. And that attorney is the one that you would discuss all of the facts of the case with. That attorney would get all of the information, we call it discovery, from the prosecutor, so that the attorney would be well read and understanding of your case. But that can't happen right now, right? So the arraignment is, so if you plead not guilty or you stand mute, so you don't plea at all, you stand mute, the court would enter a not guilty plea so that the process could continue.
I understand.
Okay. Okay.
I just wasn't planning to plead not guilty.
Well, certainly you would not, well, not certainly. Most people don't plead guilty at the time of the arraignment.
I know how this felt, and this is what happens to me. We plead not guilty. Even I've had to deal with, if you guys look, I've been in here before. I'm not proud of it, okay? But I already know what happened. The police already know what happened. There's already footage. Therefore, I really I'm not saying we have to plead right now, but I'm not gonna sit here and plead not guilty to something I did.
Then, Your Honor,
Okay, well, you don't want to,
we just entered.
we don't want to talk about that. We're on the record, right? So you don't want to say anything right now that could hurt you in the future, okay? And by pleading not guilty, you're not saying necessarily that something didn't happen, right? What you're saying is you want an opportunity to speak with an attorney. You want an opportunity to have an attorney review the footage, review all of the circumstances. And the next step in the process would be a pre-trial conference where your attorney would have a discussion with an assistant prosecutor in hopes that there might be some plea agreement that you would be willing then to accept or take it to trial, right? So this is not the time that you would want to say anything, number one, because you don't want to say something that could hurt you in the future. And so it sounds like you want to stand mute. You don't want to play either way. You just want to stand mute. Is that right?
Yes.
Okay. So the court will enter a not guilty plea. In order to go through a petition for court-appointed attorney, I need to place you under oath and ask you some questions. Please raise your right hand. And you swear that the information you're about to give me will be the truth to the best of your knowledge.
Yes, Your Honor.
Thank you, and you're welcome to lower your hand. Ms. Moore, what's your phone number and your mailing address, please? Do you use an email address?
Yes, ma'am.
Are you renting, purchasing the home, or living with others?
That is my grandmother's address.
Okay, so you're staying with her?
No, I stay in Mount Pleasant. I just have all my
Okay.
mail at her house because I'm in an apartment complex and sometimes I don't receive my mail. But I have to go, it's a whole mix up with the postal office.
Okay, no worries, as long as you can get the mail there. So this is the information that would go to your attorney and would mail you information, or might mail you information. Are you employed?
Yes, ma'am.
Where do you work?
Part-time. I'm still currently going to school.
What is your average take-home pay?
About $300 a week after taxes are taken out.
Do you receive any other sort of assistance or income?
I have EBT and through foster care now that I'm 18 and I'm independent, since like I've been doing what I'm required to do by the state, I am paid $385 twice a month.
Do you own a vehicle?
Yes, ma'am, I own two.
What is the estimated value of the combination of the two?
$14,000.
And are you making payments or do you own them outright?
I own them. I bought them both cash.
Okay,
I pay
And do you-
insurance, of course.
sure. Do you have any money in a checking account or savings account, any cash on hand or any digital currency?
No, not until tomorrow,
Okay.
but I can if needed.
So, well, this is to determine if you're indigent, meaning you have no money in order to hire an attorney. So if tomorrow you were to come into, say, $8,000, that would mean that you're not indigent, and that you would have enough to hire an attorney.
Okay.
So do you have, tomorrow, will you have enough money to hire an attorney?
No.
Okay. So I will appoint an attorney for you.
Thank you.
The next step in the process, you're welcome. The next step in the process is a pre-trial conference, and in this case, it will be scheduled for September 17th. It's at 9:30 a.m. and it's in person here at the district court. We'll mail you a notice.
Okay, thank you. September 17th at 9:30.
Yes.
Thank you.
So I show that you posted a $100 interim bond. I'm going to continue the interim bond that you posted. Ms. Mistley, pardon me, is there information that you'd like me to know regarding conditions on that bond?
No, thank you.
So Ms. Moore, I am going to place additional conditions on the interim bond. Most especially that you'll have no contact with, so that means no phone calls, no messages through other people, no mail. You may not text, message, nor through any social network have any contact with either of those individuals. You may not be at any address that they are or may be. You may not use nor possess any weapons of any sort. You'll have no threatening, intimidating, harassing, or violent behavior towards any person, and you'll be respectful of all court employees and care providers during the course of your case.
Yes, Your Honor.
You should hear from your court-appointed attorney by the 1st of next week, so please watch for a phone call from a number you won't recognize. If you
Yes.
have a voicemail box, make sure that it's empty or can accept a message in case you missed that call. Watch your mail or have your grandmother watch your mail because the attorney might mail you a letter as well or might email you. So just please watch for contact from your attorney.
Yes, ma'am.
The information with regard to the no contact will be in LEAN, the Law Enforcement Information Network, so that if you were in violation of any of the terms or conditions of that bond, you would be arrested and there would be no bond. So please understand how important it is that you are in full compliance.
I understand.
And do you have any further questions, Ms. Moore?
I know you've repeated this twice. I just want to make sure I have the correct time on the 17th. Could you please repeat to me the in-person court hearing on the 17th?
Yes. September 17th at 9:30 a.m. in person here at the district court.
Thank you.
You're welcome.
I'm sorry, I'm putting it in my calendar. I just don't want to forget. I'm good.
That's okay. All right. Thank you for your appearance and participation on the virtual platform. Again, please watch for contact from your attorney. And unless you have any questions, you are free to leave the meeting.
Thank you for your time.
You're welcome.
Bye.
Ashley Ford.
All right, Ms. Ford. Do you live at,
Yep.
do you have an email address?
It got hacked.
Pardon me?
It got hacked.
Okay, so you don't use it?
I know. I haven't used any of them in about 4 months.
Okay, and does your phone number end in 7866?
Yes.
All right. All right, you're here for a warrant on DUI charges. You had pled not guilty and were scheduled for a pretrial conference and failed to appear, and there has been a warrant for you regarding that failure to appear at a $1,000 bond. That bond will remain in place. You'll remain in custody until your next court date, which is scheduled for September 10th at 9 o'clock in the morning. So,
I
pardon me?
hold on. I paid all of my fines, and when I got that DUI, when I got out of jail, the 9 days that I was in jail, I left and went straight to rehab, and I had the lawyer handle all of that stuff. I never got any paperwork or anything. I just was told to pay the fines, and then I did.
Okay, I'll look that up because this warrant was, just to make sure we're talking about the same case, was for DUI that was related to an offense that occurred on March 16th of 2022.
Correct. I left when I got out of jail for the 9 days that I was in jail. I went straight to detox and rehab right after that, and the lawyer was supposed to handle all that stuff. And I was in rehab for a year.
Okay, your lawyer, was that attorney Tyler Allen? Or not sure?
I'm not
Okay.
positive because the rehab facility was the one that was discussing things with him, with the lawyer. I didn't have any actual contact with him.
Ms. Ford, what I'll do is I'll review the case.
I was just told to pay the fines, and then
Okay, I'll review the case a little closer after. Case, then the bond remains. And we have you scheduled for the pretrial conference because that's what it currently shows. Okay, if it's anything different, then I'll let you know that. Oh, hey, I found the fines that you paid. I found that there was an error or something like that. But as of now, it shows that you didn't appear at the pretrial conference when you pled not guilty to the DUI back in March of 2022, and that we scheduled you for a pretrial conference and you never appeared. So that's what it shows now. But I'll look at the case a little closer to make sure there's not an error in there. Otherwise, if I don't find the error that you're talking about, the bond stays in place, and this is the next court date. The earliest one I could get you is September 10th. Okay?
I'm gonna do my job.
Okay. Any questions outside of that, ma'am?
Yeah, I need to call my boss.
Okay. So yeah, phone calls. You can talk to the detention staff regarding that to determine when they get a free moment. They'll let you make a phone call when they get a free moment.
Okay, because I have no idea what's going on. I thought that the lawyer handled all of this stuff, and I just paid the fine, so.
Okay. Like I said, I'll look into it, and if that's the case, I'll be talking to you again, changing these conditions. But as of now, it doesn't show what you're stating, so I'm going to look into it to make sure. And if it doesn't show what you're stating, then you'll have the bond stays in place, and that you'll have the court date of September 10th.
Okay, can I pay the bond?
You can
Okay, how do I do that?
talk to the detention staff about calling bail bonds or making arrangements. If you know somebody that will bring the bond down to do that, then they'll give you the opportunity to use a phone. It's at their convenience because they got a lot of stuff going on, but they'll let you use the phone if you ask.
I understand that. I
Okay.
understand that. I just don't know what's going on right now, and I really would like to.
Okay, well, I don't. Can I explain it any different?
No,
Oh.
because if you don't know the answers, then you don't know the answers. I don't know the answers, so we're pretty about as stone-age, I think, so.
Yeah, well, I know the answers to what it's showing now, and so I'm going to make sure that that's accurately shown based on what you said. So I hope you're not wasting my time by having me do that if it's that you didn't show. So if we find an error, then I'm going to talk to you here shortly. If we don't find an error, then know that if I don't talk to you by 2 o'clock this afternoon, there's no error to be found.
Well, no, I understand. It's just when I didn't show up to that, when I pled not guilty and I left, I went to rehab.
Right.
And I stayed in rehab. My lawyer was supposed to take care of all of that stuff.
Okay. So just so you know, normally that's not how it works. So if you go to rehab, typically the date's held until you're released, and then you still have to show up. The attorney just doesn't fix the problems while you're in rehab.
But he never told me anything because I was in the middle of liver failure and kidney failure at that moment, and they were taking me to all my doctor's appointments and everything, so they would have taken me to court if that was the case. But I was under the impression that he handled that stuff, and like I said, I didn't speak to him. He spoke to
Some of the
rehab.
notes, when I looked at it before, some of the notes from the attorney that was assigned said that they couldn't contact you. They were unable to contact you. So I'll look at it again, look at it, review it a little closer, and then that will be the results. If there's an error, I'll talk to you again to say change the conditions. If I don't find the error, then that's where it remains.
Okay.
All right. Have a good day, ma'am.